Welcome everyone, and thank you for joining us for the third webinar within our 10 Peacebuilding Innovation series, a year-long program of events and initiatives exploring IFIT's work at the global and local level. My name is Mariana Casij. I am an associate at IFIT, where I advise mainly on issues related to transitional justice. I manage the Law and Peace Practice Group and coordinate the Peace Treaty Initiative, the subject of today's event. Today, we will be talking, as I was mentioning, about one of IFIT's most exciting projects, the Peace Treaty Initiative. It is a major global undertaking aiming to create the international law of peace negotiation. And I am very pleased to be joined for this conversation by two remarkable colleagues and members of our expert advisory group of our initiative. Sarah Nowen, Professor of Public International Law at the European University Institute, and Hesham Youssef, Diplomat and Senior Fellow at the United States Institute for Peace. Welcome to you both, and thank you for joining us. So Hesham, let's start with you. Can you tell us a little bit about what international law provides today, or what it says about peace negotiations?
Well, let me start by thanking you, Mariana, for inviting us for this important discussion. In relation to your question, I think one of the main important elements in relation to conflict resolution in international law is in Article 33 of the UN Charter, that stipulates that the parties of any dispute that may endanger international peace and security shall, and I want to stress the word shall, seek a solution by all kinds of means. They mention negotiations, mediation, conciliation, arbitration, and so on, or other peaceful means to their own choice. So this is what it stipulates. But this does not take place. And entering negotiations to resolve conflicts, as you know, is very hard. It involves huge political risks and is usually quite controversial and complicated in several aspects, whether it's in the decision to negotiate or regarding the structure, agenda, and other details pertaining to the negotiation process. At this point, if I just give you one example about the situation in the Middle East, a platform for negotiations or a structured process of negotiations is lacking between the countries concerned in almost all the conflicts that we have in the region. We don't have a platform to negotiate peace in Syria, in Libya, in Yemen, and even the Israeli-Palestinian conflict. They've had platforms on and off and so on. But at the current moment, we don't have a platform to address many of these conflicts. The international community was able to regulate war, but so far it does not provide incentives for states to choose negotiations over continued confrontation or military action to end conflict through peaceful means. And I think the decision to negotiate is always associated with huge risks and high costs, especially when it is related to armed groups or when it's related to having discussions or some form of understandings with terrorist groups or organized criminals, or different conflicts, whether it's at the national level, regional level, or at the international level. And when countries decide to negotiate, there is no organized framework that offered a balance between legal clarity and flexibility at the same time, making peacemaking even more challenging. And if an agreement is reached, it is not clear whether it would be in conformity with international law or not. So the situation is quite difficult, and this is what we see at the international level with all kinds of conflicts going from bad to worse.
Wonderful, thank you, Hesham. Sarah, what does the peace treaty intend to do with these issues that Hesham was explaining?
Well, that's the thing. So Hesham has clearly laid out that there's kind of something missing in the international legal framework. And if you think about international law clearly has certain community interests, things that affect the entire international community. And how do we identify community interest? Well, first of all, we look at what states and other actors have said is important, and peace, including peace in states, so i.e. preventing or stopping civil wars, is clearly an international community interest. But the second thing that's necessary for the protection of community interest is an institutional framework. And we've seen this in other areas of international law, international criminal law, international human rights law. These were not very lively or effective areas of law until we had legal frameworks, until we had treaties, until we had mechanisms to actually give these international norms teeth. Now, Hisham has already referred to the fact that we have some references in the UN Charter that says, please negotiate because it's so important, but in practice, very little happens with that. Now, and what does the Peace Treaty Initiative do? I think it tries to do three things in this proposed treaty. First of all, strengthen the norm of mediation. So make it more normative to engage in peace talks rather than try to solve conflicts militarily. And this is hugely important because very often for governments, it's a huge risk to start talking with the national enemy, the rebel movement, terrorists. And by making it more normal, by making it more of an international expectation that this is the way to resolve conflicts, talking, you actually reduce those costs of talking. The second thing that the Peace Treaty Initiative does is when talks are ongoing, strengthen that process. And that it does so in a few ways. First of all, it provides certain guarantees for the parties and the mediator that they won't be immediately arrested the moment they get to the talks. They give certain protections. Secondly, it provides for financial support. There's a fund to support, but also for expertise. If you need international expertise on certain topics, it is available. So there is this whole framework available for those states who make the choice then to follow the process of this Peace Treaty Initiative. And finally, as Hisham mentioned, the outcome. At the moment, and Mariana, you've got a lot of experience in Colombia, and that's where this was also an issue. There's constantly this question during the peace talks, is this agreement going to falter, not because of a lack of will of the parties, but because an international court, international criminal court, or an international human rights court, or other international actors don't respect it because they argue that it's not compatible with international law. And this Peace Treaty Initiative, the proposed treaty, proposes benchmarks, things that these agreements have to consider when negotiating, but then also offers a presumption of conformity at the end, which gives the agreement and therefore the parties a bit more stability. And I've observed the Uganda peace talks quite closely, and I really think that such a presumption might have made a big difference in the Uganda scenario, in the talks between the government of Uganda and the Lord's Resistance Army.
Thank you, Sarah. So the idea is basically to create an international law that can rule peace negotiations, and that can help peace negotiations being more attractive in the beginning, more organized and structured during the talks, and more sustainable and have greater legal certainty afterwards. But if this means creating a legal, basically codifying, Hisham, codifying peace negotiations, some might say that this is incredibly dangerous because negotiations are contextual, because negotiations are so particular case by case. Wouldn't you say it can be risky to attempt to create a legal standard for such a particular and contextual initiative?
You're absolutely right, Mariana. It is extremely contextual. It's not only that, even the same conflict can be dealt with in a different manner at different stages of its evolution. So I'll give you an example of Iraq, for example. So dealing with Iraq when it was under occupation by the United States and the UK is one situation. After they left, and then the Iraqis started working on reconciliation, then it's a different story. Then we had ISIS, and they had to deal with the situation of ISIS. And then after that, they have their own massive demonstrations and difficulties with the population. So these are 3 or 4 different ways in which this conflict needs to be addressed in totally different ways. So this is why I don't think the codifying is to put constraints on the situation. No, I think codifying is providing a framework, and the framework can deal with all kinds of issues. And I think one of the elements that, a number of elements that are important, I think Sarah mentioned some of them, but there are others. There is the issue of sovereignty that is quite important to countries that adhere to different agreements. There is the issue of flexibility, and there is the issue of ownership. So if we talk about sovereignty, the proposed treaty does not impose on a country to use its provisions, except when they decide to do so. So it's a voluntary process that provides additional options that are consistent with international law for countries to deal with the conflict. And if a state party continues to retain control over whether the conflict will be handled under the treaty or not, and it will not diminish its sovereignty. As for flexibility, this is important because of the contextual nature that you're talking about. So the proposed treaty also allowed the conflicting parties to control the negotiating process and at the same time provide them with a support system that is currently lacking. We don't have this supporting system that is codified in any way in international law, and a clear mechanism for validation of key elements on which they will agree. And finally, ownership. And I think this is a crucial issue for parties that are part of a conflict. They want to ensure that they are in control of the process. Of course, they can be helped by others, whether they are mediators or good officers or otherwise, but then they need to feel that the decision is up to the conflicting parties to reach an agreement. And this is also a third important element, which is the question of ownership, to be able to control the process.
Thank you, Hesham. Sarah, you were mentioning the idea or the importance of having law. So why do we need law, and why not something else?
Well, so this really goes also to Hisham's answer and your earlier question, because with law, you could argue, oh no, law always claims to be universal, at least international law. And isn't this going to try to provide universal solutions to local, always by definition, local problems, in the sense that they have their local characteristics? They're usually, of course, always internationally influenced, but they are all unique in one way or the other. So isn't there then a big risk if we prescribe a universal law? This is the law of peace negotiations. But here, this is a different kind of law. Law fulfills different roles. Law can prescribe, but law can also enable and set expectations and set standards. And here you really see more this incentive-driven, enabling law. At least that's what one gets the impression if one reads the draft articles. Namely one that provides a safer space for those who want to end conflict through talking rather than picking up arms. And the issue is, we see in our world that a lot of stuff gets legalized, that there's a lot of, everything becomes more and more law. And it's just remarkable, given the universal agreement that peace is an important value, how little institutionalized the value of peace is, especially in non-international armed conflicts. So you see that human rights has got its legal instrumentarium. You see that international crimes have got their legal instrumentarium, but peace doesn't really. And if you don't provide a framework that promotes that value, then these other areas may not leave enough space for promoting the value of law or for the value of peace. And that's exactly what this treaty wants to do, if I read it correctly.
That's very interesting. Thank you, Sarah. Hesham, can I get back to you with an additional question? Some have said to us, well, it might not be the best time to be creating new international law. What is your opinion on
that? Well, first, let me make a comment on what Sarah said, because I like this concept of institutionalization of the value of peace. And I think this is quite important. But in response to your question, I think, you know, the state of the world today, in as far as conflict is concerned, is dismal. And we have to do something about it. Whether it's protracted conflicts in different parts of the world, or whether it's the situation in the Middle East. I mentioned Syria, Yemen, Libya, a number of failed states, the war in Ukraine, and so on. The world has been failing in ending conflicts. And we have to admit that in order for us to start thinking about what needs to be done. And there is an institute that has been working for a few years to provide an answer to that question. If people don't like this answer, by all means, let them come up with another idea to say, okay, no, we think that the failure can be dealt with in this way. So I think one of the huge advantages of this idea is that it opens a question that is being avoided, that no one is wanting to talk about the failure. Of course, this is not the only failure. We have many failures. This is one of them. We also have another failure in relation to prevention. This also needs to be discussed. But I think what is being proposed now is a question of trying to end conflict in a faster way, in a more effective way, so that the world can be somewhat more peaceful than the havoc that we are seeing around us in different places around the world.
Thank you, Hesham, for such a compelling argument and statement. Sarah, back to you. So we are talking about, and you've mentioned that the idea is to create an incentives-driven treaty. What kind of incentives does this treaty actually include, or what does it aim to do?
Yeah, so I think the first incentive, and look, the incentive, it all sounds very economic, right? And I don't think we should think about the cash flows going around here, but it's more about what is normatively felt to be the right thing to do. At the moment, for governments to enter into peace talks with those whom they have always portrayed as the ultimate enemy is hugely politically risky. And we all know that governments live with very short time spans because the elections are always around the corner. And therefore, being strong and addressing demonstrators militarily may seem more appealing than engaging in peace talks. But if that country itself has signed up to a treaty that says, look, these conflicts should first of all be prevented, Hisham's point, and one of the ways to prevent them is actually to start talking quite early. But secondly, once you're in them, then to deal with them through peace talks rather than militarily, it creates more of an international norm that this is the right thing to do. And Hisham referred to the UN Charter. But the interesting thing is that if you read the UN Charter carefully, some people read it saying that it only addresses international armed conflict. Now, you can also read it to say, well, perhaps it's any dispute. But long story short, the UN Charter has been very interstate oriented and actually very hands-off for sovereignty reasons when it comes to non-international armed conflicts. Therefore, one of the things that this treaty does is just make it politically more the thing to do is to talk peace, or to enter into political negotiations with the IRA, with the FARC, with the Lord's Resistance Army, rather than making this kind of this untouchable thing. So that's the first incentive. The second type of incentive is more when the talks are ongoing. I mentioned the example of Northern Uganda. Look, I can't read Joseph Kony's mind. I don't know what exactly he thought. But even from an objective kind of distant analysis, one can understand that if somebody never attends the peace talks because of a fear of being arrested by an international criminal court, that function that peace talks fulfill subjectively in the relationship between parties, that trust building aspect cannot materialize. So the threat of arrest, and this was for Joseph Kony, who has an ICC arrest warrant above them, but even for mediators, there's sometimes a fear that they will be arrested because of being seen as providing material support to people who have been listed as terrorists somewhere. The threat of arrest can be an enormous impediment to talking. And therefore, the provision in this treaty that during the talks, and only if these talks have been approved by the Assembly of States Parties, so there is political oversight, they cannot be arrested, is an incentive for parties to talk peace. Now, and then finally, this presumption of conformity at the end can give some form of political approval that we think the Assembly of States Parties, who has not undermined that presumption, that this agreement is compatible with international law. So it provides incentives to go to talks, during talks, and for the outcome of the talks, if those talks have complied with general expectations about, for instance, thinking about victims' rights, victims' interests, and also the duty to provide, to take care of accountability.
Thank you, Sarah. So Hisham, I would like to ask you just one last question, and it has to do a little bit with what already exists. So there are mechanisms in the UN, and how would you say this treaty would speak to the already existing mechanisms?
Well, I'm not sure how formal these mechanisms that you're talking about. Well, we're talking, for example, about the role of the Security Council. And as a result of the war in Ukraine now, there are those who are expecting that the Security Council will be paralyzed in the next few years as a result of the problem of the war in Ukraine, that Russia will be trying to annoy a number of Western countries, and the Western countries will be trying to annoy Russia in return, and then this would result in some form of stalemate on all kinds of issues. Will this happen? We will see, but the likelihood of this to happen is great. But I think there are elements that are not addressed by the current mechanisms. So, for example, and I think Sarah alluded to that in her last response. At one point in time, for example, in Lebanon, they agreed on forming a government in which Hezbollah is part of the government. And then a number of Western countries, as a result of the fact that they consider Hezbollah a terrorist organization, they said, okay, we will not deal with this part of the government that is run by members of Hezbollah. And similarly, at one point in time, after the elections in the occupied Palestinian territories, and Fatah and Hamas produced a government in which they were members of Hamas, also you found Western countries saying, well, we will not deal with this government. If there is a mechanism that would allow the international community, if this is reached in a manner that is accepted, or there is a presumption of conformity with a broad number of countries, then this would make a difference to the international community. So I think that is an important dimension of the situation. Sometimes it happens informally. So at one point in time during the conflict in Yemen, it was agreed that Ali Abdullah Saleh will receive impunity in order for the situation in Yemen to proceed in a peaceful manner. Of course, he went back on his promise after that, but we don't have a system whereby this can take place in a codified way or in a structural way. No, it is done through ad hoc arrangements through the intervening of one party or another. And the case of Ali Abdullah Saleh, for example, was through the Gulf Cooperation Council and other countries in the Gulf. So if it's done in a different way, perhaps in a more structural way, then this can be addressed more effectively. So we will see. This is an ongoing discussion, and member states will have to weigh in, and other bodies and experts will have to weigh in, and we will see how this dialogue evolves in order for this to be, in order for this to evolve in a way that is acceptable to more and more people.
Speaking of dialogue, can we reverse the tables for a moment? I would like to ask Mariana a question, because you're asking us the question as if we are the experts. Well, I mean, we've read this text, we hear about the ideas, we find it interesting, but you're doing this on a day-to-day basis, and you're making not just this text, but this reality. So can you tell us more about the process, and also if people want to know more or want to get involved, how they can be part of this global project?
Yeah, thank you, Sarah. Sure. So the idea of the Peace Treaty Initiative is, and taking into account many of the things that both you and Hisham just mentioned and put on the table of where we are now, where the world is standing now with regards to international law, and how, so we've asked ourselves the question, how to really make sure that what we're creating actually does the difference, and that it is reality informed, and that the treaty that we propose is shaped by good practices, by lessons learned on the field. So for the past year and a half, we have been conducting a global consultation process on an indicative text that we have been putting under consideration of a diversity of actors. So we have been gathering views and perspectives from scholars, from experts, from jurists. And just to give you an example, we met with negotiators of the Doha peace talks to analyze how this treaty could have made the difference for Afghanistan. And we promoted a regional exchange with academics from Latin America and the Caribbean to understand how this treaty could, because we believe it should, how this treaty could actually embrace new types of conflictivities, new types of manifestations of violence, so that it doesn't only look backwards, but it's also looking forward. And we have met with victims, we have met with technologists, we have met with lawyers, we have met with practitioners, and we're still ongoing. So our aim is to continue working. We are finalizing now the second version of the treaty, which will be draft articles, and we invite everybody who is listening, of course, to participate, to engage, to give their feedback, their impressions. And our aim is to forge incremental consensus, to develop a global alliance of networks, organizations, states, and finally, to be able to organize a diplomatic conference of states that could hopefully lead us to the adoption of the treaty. So this would be it for today. I see that we're almost out of time, but I really wanted to thank you, Sarah and Hisham, for being with us today, for sharing these very valuable insights, and also take this opportunity to thank you for all your contributions for the project. And thank you everybody who is joining us today for today's discussion. We very much look forward to having you during the rest of our 10 Peacebuilding Innovation series, the next of which will examine the process design of secret talks, taking place as negotiated solutions to an armed conflict or political crisis. And this will take place in January, and you will, of course, be receiving an invitation in the upcoming weeks. So thank you again so much, everyone. Sarah, Hisham, again, thank you for joining us.
Thank you.
Thank you, Mariana.
Bye-bye.
Thank you, Sarah.
And happy birthday, IFIT.
Bye-bye.
Happy birthday, IFIT. Yes, thank you.